All rise.
Where Johnny?
All rise for the judge, Nolan.
Oh, bro, I'm not gonna be able to sit back down. Goddamn.
What's it, John? Sit chair, what?
All right. The High Court of Liberty 99 is now in session. I am the Honorable Judge Nolan presiding. This courtroom is reminded to maintain proper decorum. Please ensure you have muted your mics unless called upon. Witnesses, with the exception of the plaintiff and defense, are reminded to wait outside of the courtroom until they're called to the witness stand. Today we are here regarding the case of Freeman VPD. Will the parties please identify themselves, starting with the plaintiff? Can you identify yourself for the record, please?
Daniel Freeman.
And your attorney?
Defense attorney Heather Bundy.
Not yet, defense. Sorry. Plaintiff
I
attorney.
apologize.
Laura White.
Thank you. Defense. Can I...
These washroom.
All right.
Defense attorney Heather Bundy.
All right. Thank you. Defense, you are reminded that you always have the right to remain silent and legal counsel, and the right to present evidence, and the right to be cross-examine any witnesses that testify against you. Do you understand these rights?
Yes.
Yes, sir.
Judge.
Are you guys satisfied with the legal representation you have so far?
Yes, sir.
Yes.
All right. This is a civil suit alleging police officer misconduct. Does the police admit or not admit liability for the allegations levied against them?
We do not admit liability.
The defense does not admit liability for the alleged misconduct, and we shall now move to opening arguments. Plaintiff's counsel, please begin your opening arguments. As a reminder, our opening arguments are not a time to bring up evidence. You are simply outlining what you intend to prove and highlighting the evidence that you want the finders of fact, i.e. me, to pay attention to. You may open up.
I think that's you.
For defense, I thought they said
No,
plaintiff.
Plaintiff opens up. Plaintiff attorney, please come up to the podium and make your opening arguments.
Hi, I would like to say my name is Laura White. My client over here, Daniel Freeman, is not guilty. He was never originally under arrest. He was just there to pay the fines for his friends, just to help them out. And an officer arrested him without probable cause. And my client was shot after stating that he wanted a lawyer because they falsely arrested him. He wasn't posing an immediate threat. He wasn't using any deadly force. They just retaliated against him for exercising a protected right for him. The officers failed to ask him any questions before shooting him unlawfully at that. Sorry, was good.
Thank you, counsel. You may be seated. Defense, you may proceed with your opening arguments. Just like before, I'm reminding you that this is not a time to bring up evidence. You're simply outlining the arguments you intend to prove and highlighting what evidence you want me to pay attention to when it comes to that point.
Yes, Your Honor. Good evening, Your Honor. My name is Heather Bundy. I represent the entire PD department. I'd just like to say that the burden of proof rests entirely on the prosecution. My client is presumed innocent unless the state proves every element beyond a reasonable doubt. Because right now, this case is built on assumptions, not proper evidence. The prosecution is asking the court to fill in the missing pieces instead of presenting proof. So what I'd like to tell you, not to go into the evidence, but to let you know the evidence will show missing documentation, identification, and it is all entirely speculation. There's no direct evidence linking my client. That's all I have for now.
Thank you, counsel. You may be seated. Plaintiff, you may call your first witness.
What's it called?
All
My witness for the case, Daniel. Can you stand on the stand real quick, let me please? Can you tell
Yes, sir.
eyewitness court of this can you give your statement, please?
1 second. Witness, do you agree to tell the whole truth? I'm sorry. Do you agree to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, you may begin your questioning. Thank you, counsel.
All right. So Daniel, so you said that you were arrested by SWAT.
Yeah, at the first, before we got bailed out. Yeah.
They brought you to prison,
Yes, sir.
and then so did they bring you to the interrogation room, all 7 of you, or where were the other ones held?
No, they were at the lobby, and I was taken to the locker room to pay the bails. And that's it.
Okay, and what was the amount of the bails that you had to pay?
7 million, 1 million per person.
Okay, and you paid those bails,
Yes, sir.
and then what happened after you paid those bails?
After I paid those bails, we got they took the cops out of us, and we went to take our cars, and the PD just started to arrest people.
Okay. Do you have any recollection of why the PD would start to arrest you?
I have no idea.
Okay, and then so you were already um on the way to grab your car, and then someone. So I have no further questions, Your Honor.
Plaintiff
Or
attorney,
Daniel,
is there any evidence you would like to enter onto the record? If so, please be specific on the time frames. I will only view.
I would actually like to say around time of okay, I would like to say around the time of 4 minutes and 4 minutes, around 4 minutes.
And when would you like me to
I would
stop
like
viewing?
to see that last 4 minutes there. 4 minute there.
4 minutes until the end.
And that 4 minutes. So basically, the last minute of that clip where 3:59 starts.
And
Or
what?
actually, you know what? Yeah. 3:58. Wherever
3:58.
3:58 is.
Understood. Can you explain to me what this evidence is and why it's relevant to the court case?
So, while while it's relevant, there was arrest being made in the scene, at that scene, but while that was all happening, there was discrepancy within my client, but also in the fact of the matter, my client was not arrested and also off the scene, but then pointed.
I'm going to pause you 1
the
second,
officer.
counsel. I mean specifically, who recorded this evidence?
So basically, the officer who then started to point at his gun or his non-lethal at my client,
and you're
killed my client.
the evidence you want me to view was recorded by your client, correct?
Yes, yes.
So
Yes,
entered
yes.
minute 3:58 seconds till the end. I will be muting myself here while I review the footage. I will make sure it is included in the uploaded video. Stand
Yes,
by
sir.
one, please.
Yes, sir.
Come right back after these commercials. Following broadcast is brought to you by PBS. Where a kid can be a kid.
I'm a big kid now.
I'ma fucking shoot your ass if you don't get the fuck out, bro.
The courtroom is reminded to remain on mute unless called as a witness. Thank you.
Yo.
The room is to remain on mute.
Oh my fucking god.
Yo, what are they doing? With 22 kilograms of baggage.
Yo, what the fuck you guys doing, bro? We paid the bail.
I would like to.
I paid fucking 7 mil, bro. Bro.
They already paid.
Oh
They
my
already
god.
paid, bro. Just let them go.
What the? Yeah. Let's call a lawyer. Let's get a lawyer.
If they're talking in the courtroom, I can't hear it. I'm still reviewing the video. I'm sorry.
They are.
I'm gonna call
Hey,
a
I'm
lawyer.
sorry.
Yo,
Everybody, can
you
you
can't do
please
that, bro.
be quiet?
Yo,
court
shut
is
the
in
fuck up,
session.
bro. I bailed out, bro.
Please, just
Yo.
remain silent.
Yo.
What are you doing? Why are you tasing, bro?
All right, I have concluded viewing from 3 minutes, 58 seconds until the end of the video. Thank you.
And Judge, as you can see, my client was unlawfully detained and also tased and killed. At the end of the day,
Counsel, I'm gonna ask that
are
you.
going-
I'm gonna ask that you save these for your closing argument, please.
Okay.
If you have any questions, you can direct them towards the witness.
Okay. Yes, sir. Can you stop doing that, please? Stop. Please stop.
Do you have any additional
I love
questions
you.
for
I
your
love you
witness?
so much. No. No, I would like my witness to come back and sit on the stand, please.
Unfortunately,
I
no.
would
He
like
has
to
to stay up here.
cross-examine
Yep.
the witness, please.
Witness, please come back. Counsel, you may have a
Yes, sir.
seat. Defense, you may now cross-examine the witness.
Okay, thank you so much. Okay. Based on the evidence that was just provided to you, Your Honor, I would like to break that down, if I could.
As
Okay.
long as you do that while asking questions to the witness. If you want to make actual arguments, you can save that for closing, please.
Yep, absolutely. Okay, so my first question is going to be this. Do you have the identification of the officer that arrested you? As that was
The one
not-
who shot me, at least. I'm not sure about. Was it the same guy?
So based on the evidence, Your Honor, that was submitted to the courtroom and the timestamps, there is no identification that
Actually, it is the
shows
same guy. Yeah.
that
He had-
shows in the evidence the
Objection.
guy that
Objection.
unlawfully detained him.
1 second, there's an
question is this,
objection.
I will
1 second, there's an objection. What's the objection?
Objection. He just said that he had the evidence. He has the ID.
At
Okay,
the
where is that
body cam,
evidence? It was
at
not
the body
submitted.
cam,
Okay,
you'll see
one at a
he's the only
time.
one who has the taser.
One at a
who
time. The
cuffed me.
record can only record one person at a time. Defense counsel, please ask your question again.
Okay. Based on the evidence that was submitted by your plaintiff attorney to the judge, there is no evidence at this time that shows identification. So my question is this: do you know who the person was that unlawfully detained you?
Objection.
What is your objection?
There is evidence.
Your objection
Not
is
submitted
overruled.
at this time.
You may continue, defense.
Again, based on the timestamp at, he said 3:59, 4 minutes. Up until the end, there is no
Since when it's the state?
there is no body cam evidence that shows ID of the person that detained him. He then proceeds to this.
Counsel, is there a question here?
Yes. So.
No, defense counsel,
my,
please.
Okay.
Yes, he didn't answer my first question. Do you know the identification, the name, and identification of the person that unlawfully detained you?
Yes, it was Paz, ID 56572, the same one who tased me.
Okay. Your Honor, can I ask a question?
Yes, it's your witness.
No, can I ask you a question?
Oh, you want to approach the bench?
Yes, please.
Okay, both attorneys, please approach.
Yeah, you're done. You can sit back on the side.
No, witness, stay there. Attorneys, come back here, please.
Witness, come back.
Yeah, but you stay down there.
Okay.
You're dismissed from.
All right.
Okay.
Thank you, counsels. Witness, can you please return to the podium?
Daniel.
Yo, what?
Can you please return to the podium, sir?
Yes, sir.
Defense, you may continue your cross.
Okay. Okay, Daniel. My next
Yes,
question
Heather.
for you. I apologize, I'm just getting familiar with this case. I was brought in last minute, so just bear with the patience here, okay?
You're good, you're good.
From my understanding, based on the evidence provided, you paid bail to
Yes, ma'am.
a SWAT officer.
Yes, ma'am.
So for PD's purpose, why would you think PD should know that you paid bail when you paid it to a SWAT officer and not a police officer?
Because
Like
the
if they were
SWAT
outside,
told them many times.
where in the evidence does it show that
They
SWAT
were
told
they were
police
shouting at
department
them that let them
outside?
go. They were shouting at them that let them go.
Okay, the one
And
that
I
was
told them
outside.
many times that I paid bail.
Okay, so the one that, based on the evidence, the one that was outside, that unlawfully detained you, tasered you, everything, right, based on evidence,
That was
he was
inside, yeah.
outside the whole time. There was no evidence to support that he was inside the building. Therefore, my question again will be, I'm
Objection
answering
has
my
been
question.
launched. What is the objection?
That was PD that stated them.
Overruled.
It was PD that what?
PD
Overruled.
Okay, that's.
That means you can continue on with your questioning.
Thank you so much.
Yes, I've overruled his objection.
Okay. So again, my question is, how is PD expected to know that you paid a SWAT officer in a locker room when all of PD is outside in that video, give or take a few that were inside? How is that one that unlawfully detained you under reasonable suspicion supposed to know that you paid bail?
So that's not our problem, to be honest. That's their problem to inform their officers, not our.
Right, but you have to understand that SWAT and PD are separate entities. They're on
I
different
know, but
panels.
PD got told, as you see in the evidence. After 1 minute, the PD is inside and they are letting our guys go.
Stop. Hey,
So.
Brody, stop talking loud. Whoever just said that, stop talking loud. Just be quiet for a second.
So I'll proceed to my next question then, okay? The one that unlawfully detained you and tasered you, according to evidence, was not inside at the time that bail was paid, nor was he holding any of your officers inside. So again, I will ask how, if he's doing under the right of the law and he has reasonable suspicion based on the numbers of gang members that were outside, how was he supposed to know that you paid bail?
What do you mean? They have radios.
Yeah.
Okay, but again,
not
SWAT
connected.
and police are not on connected radios.
Yes, but they have radios. The
Is there a
PD who was
question,
inside
counsel?
Okay, no
selling.
further questions. Your Honor.
Yeah, there's no questions. Okay,
No
all
questions.
right. I would like to also continue this cross-examination.
Okay,
Hey,
redirect, plaintiff. You may begin your redirect.
so hey, so you paid these guys. They took you. I would like to bring this to another, but if you would like to just kind of summarize and paraphrase to the best of your ability why you got arrested by SWAT and you were brought there. But also, actually, you know what?
Mm.
Yeah, I would like you to paraphrase why, in the best of abilities, why you were brought there, and how much of the sum that you paid. And then I would like you to state the facts of why. This is a full statement. I'm
Say, counsel,
towards.
I'm waiting for a question still, please.
No, this is the question. This is the question. I would like you to answer these questions. Why were you there at the PD?
I mean, we did illegal stuff. We know that. They know that. That's why we paid bail.
Okay. And you paid the bail a sum of what?
7 million. 1 million for each head. There was
And
7
who
of
was
us.
the arresting? Who arrested you at the scene?
I don't know his name, but it was SWAT at the scene, and the one I paid bail to, who bring us to the jail, it was Jackson, SWAT officer.
Okay. And then when you went to when they brought you to PD, you paid your bail, right?
Yeah, the prison, not PD.
Okay. Yeah, when you went to the prison, right? Sorry.
Yeah.
You went to the prison and you paid your bail at the prison. Okay, cool. At a total sum of 7 million, you said?
Yes, sir.
Okay. And when you then decided to walk out to your car, there was no escalation of violence towards you, right?
No, sir.
Okay, and then when you went back into the building, there
One second,
was
counsel. I can't see who timed out. I just want to make sure that that isn't defense.
no,
Okay.
No, it's not.
Okay.
It's not.
Sorry, you may continue.
And then when you went into the, I'm sorry, okay, so then you went into the building and there was no assault on presence until you started to pull out your phone, right? And you called for a lawyer?
Yes, sir. Yes, sir.
Okay. All right. No further questions, Your Honor.
Thank you, defense. You have the option for cross. Sorry. Yes, cross redirect. If you would like.
Yes, I would love that. Thank you so much, Your Honor. I just have one last question for you, Daniel.
Yes, Heather?
Okay. Based on Liberty99's city rulings and regulations for police officers, it does state that wearing a mask or a holster requires a mandatory search. So
Yeah.
in order to search you, we do have to detain you to do that. And as you were outside, walking outside, again, under reasonable suspicion, my officer, based on your attire and the fact that you had a gun holster on you and a mask.
Objection.
Sustained. Please get to a question, counsel.
Okay, so my question is, how did he unlawfully detain you?
Because I
How was
already
that
got
unlawful?
out. I already got out.
Objection again, Your Honor.
What's the objection?
Self-expression.
Overruled. Defense,
thank
you
you,
may
Your Honor.
continue.
And then proceeding once more to ask one final question is the officers that were outside, you know, they see gang members, they see gun holsters, masks. My question for you is, again, well, I guess I already asked that question. It's fine, Your Honor. I have no
I
further
was
questions.
just released. I was just released.
Sir, no question was asked.
Yeah, no further questions.
Thank you very much. Witness, you may be seated.
Sorry, yeah, no, you
Yes,
have
sir.
to sit down. Sit down now.
Plaintiff, do you have any additional witnesses you would like to call?
Let's see. I would actually like to call one of these boys who are AFK. Who is the boy
If they're
that
not
got
available, I'm not
arrested?
going to allow them right now.
Hey.
Hello?
What's
Who is the boy that
AFK?
got arrested? Who is the boy that
Actually,
got shot?
I got shot.
If your witness is currently in the courtroom,
Me
I'm
with
not
the
going to allow them to
taser.
testify. That's
Alright,
not
yeah,
going to
no,
work.
they're good.
Okay.
Sorry.
Defense, do you have any witnesses?
Not at this time. There was not enough time given in this court to obtain defense victims or anything like that, witnesses.
All right, thank you, counsel. At this time, I'm going to call a 5-minute recess while I review the evidence again and I deliberate. Counsel, please ensure you and your clients are seated and ready for the ruling at my time. Again, I'm going to take a 5-minute recess. I will be back in 5 minutes.
All right.
The court is now in recess.
All right. Sit down.
All rise.
I can't.
All rise.
All rise.
All right, now they can sit. This is a tough one. Let's see. I don't think anybody's going to be happy with my ruling. I've already made my decision.
Don't even say it.
I have to say,
Don't even say
I've
it.
already made my decision.
You have?
I think
Damn,
so, yeah.
that was quick.
Based on testimony and the allegations and everything. I'm just trying to figure out how I want to word everything. I see shadows, but I don't know who that is.
I still see your shadows in my room. Can't take back the love that I gave you. It's to the
It's to the
point where I
point where
love
I
and
love and
I
I hate you, and I cannot change you, so I must replace you. Oh,
easier said than done. I thought you were the one.
All right, I
you
think
just
I'm ready to go in. I'm just
fired a
gonna
shot on my head.
just
Okay.
Oh, get you sorted?
yeah. I got my notes on my outline.
Yes, sir. I'm gonna go grab the
All rise.
The judge is coming back.
Computer, make this judge win.
Xbox turn off.
Computer, make this lobby
All right,
quiet.
order in
The
my
judge
court,
is coming back.
please.
Order.
Order in my court. All right. I have reviewed the evidence. I have considered the testimony and the questioning provided, and I have made my decision. As I provide my ruling, the courtroom is reminded that this is a final ruling, and I will not be hearing any additional Oh, I'm sorry. I forgot to go to closing arguments. So never mind. I have not made my decision. Plaintiff, you may go into closing arguments. I take that back. This is your last chance to convince me both sides.
Well, the other side is not here.
She's not here yet? They're not here yet? Okay, well, I will let them come back.
With that, Judge,
Please wait until the defense is here.
Sorry, sir, but if I'm in a convincing mood, it seems like...
One second. Is the defense here?
Back.
Okay,
coming
one
back.
second. 1 second. All right. Wait. They need to be here.
If I'm in a convincing mood and you started
Mr.
the
Appleseed,
court
please
and
wait.
they weren't here...
Mr. Appleseed, while I appreciate your contentions with this is my courtroom and my decision.
Sit your ass down before we arrest you for getting too close.
All right,
to the
again, half of you guys are still invisible for me. Are we all here? Miss Heather, are you here?
You need to go
Okay.
sit in your corner over there.
All right, order, please. All right, Mr. Appleseed, you may make your closing arguments as plaintiff attorney.
Okay, all right. Well, as you can tell, Judge, from and witnesses of the court. Okay, all right. Let me get a little bit closer so you can hear me. So as you can tell, Judge, from the footage here and witnesses of the court, you can see that my client has been clearly wronged, and he has paid a sum of $7 million to someone who wasn't supposed to receive that payment in the first place because they did not have the right procedural booking processes. Anyways, on top of that, they paid $1 million to that person. Said person was not the one that killed my client, it was one of PD's very own trainee who has not been trained on a personal. No, they were not trained to escalate any procedures involving bookings. So with that being said, my client should be awarded the 7 million plus a 2.5 million, making it a 9.5. Even it out 10 mil if you would like for restitutions. Oh yes. For even being here in the first place. That's 10 mil. I'm sorry, Judge, but I think we're going for 10 mil at this point. It was the 7 mil that he paid for, and now we're going for 10. That extra 3 is a restitution, and the fact that he had to just pay in the taxes, like taxes, paying on taxes.
Objection.
What's the objection?
They would have to sue SWAT, as the person that received the money.
No.
It has nothing to do with PD.
That you can save for closing arguments, so overruled. All right. Counsel, do you have any additional arguments to make?
No, sir.
Thank you. Defense, you have final say and final closing arguments, please.
Beautiful. Thank you, Your Honor. Okay, I'd like to address the court as a whole. Your Honor, at the beginning of this trial, I told the court that this case was built on assumptions instead of evidence. After hearing the testimony, reviewing what's been presented, the evidence, that's only become more apparent. The prosecution has one burden alone to prove that every element of their case has reliable evidence. They do not get to rely on assumptions, guesses, conclusions. They have to prove it. Today, they failed to do that. The prosecution alleged that my client improperly paid bail for multiple officers, yet throughout this entire proceeding, they failed to produce one of the most basic pieces of evidence to support that claim.
I would like to object.
Let me hear your objection.
Arguments.
I'll hear the
It is
objection.
in the footage. It is
Overruled.
in the footage. 7 million.
Overruled.
7 million in the footage.
Your objection has been Your objection has been overruled. Thank you.
Okay, I will proceed. What are the officer identifications? Who took the payment? What officer took that payment from SWAT? What single SWAT officer took that what is that officer's identification? Where are the arrest records identifying the individuals involved? All 7 individuals. It's
overruled. We're in closing arguments.
Where are the ID numbers tying each recipient to those payments? Where are the booking records? Where is the transaction records that shows the individual payments, not bulk payment? Where is the evidence connecting my client directly to each person they accused him of paying for? It simply does not exist before this court.
One second. I'm hearing an objection. Plaintiff, we are in closing arguments. Objections about evidence are no longer applicable. Please allow counsel to make her argument. You may object for any egregious errors in proceeding at this point, but not against evidence or arguments.
My fault, Judge.
All right, thank you.
Thank you. Instead, the evidence established only one thing. A bulk payment was made to a single SWAT member, not PD member. From there, the prosecution asked this court to assume everything else. Assume who received the money, assume who was arrested, assume who benefited, and assume that my client intended every alleged payment. But courts do not convict people based on assumptions. They convict based on evidence. If the prosecution can't identify the very individuals whose bail forms the basis of these charges, then they have failed to establish a critical part of their own case. If they can't produce any identification for any of the people that were arrested, there's no evidence that shows who the arresting officers were, the booking information, who was allegedly involved. The evidence is incomplete.
Plaintiff,
I'm sorry, I would like to finish.
Please allow counsel to finish her arguments. Thank you.
Our justice system exists to prevent convictions based on speculation. It doesn't shift to defense to fill in the prosecution's missing evidence. We're not required to explain gaps in their investigation or prove an alternative story. Their burden remains exactly where it started with them. We heard opinions, we heard allegations. Those aren't evidence. Conclusions are not proof. Speculation isn't proof, but beyond a reasonable doubt. Your Honor, if the prosecution believed these identifications, arrest records, and supporting documentation were essential, they had every opportunity to collect them, preserve them, disclose them, and then present them to this court. They did not.
Can I
The
call for
court can
conjuncture?
No, this is closing arguments. The only objections you may lodge at this point are any egregious procedural errors. She's allowed to finish her arguments.
Thank you so much.
But I just wanted to correct her, but it's okay.
Well, plaintiff,
This
you had
court-
your opportunity to make your argument. This is now defense's turn.
Sorry, sir.
This court cannot simply overlook missing evidence because the prosecution believes that they know what happened. The law demands proof, not confidence. It demands evidence, not assumptions. And it demands certainly beyond a reasonable doubt, not probably. So because this is my final closing statement, because the prosecution has failed to identify the alleged recipients, failed to produce the underlying arrest documentation, and failed to establish a complete chain of evidence connecting my clients to the conducted alleged, they have not met their burden. For those reasons, I respectfully ask this court to find that the prosecution has failed to carry its burden of proof and enter a verdict of not guilty on all charges. I would like to file for a mistrial. If the court determines that the missing evidence has materially prejudiced the fairness of these proceedings under the server's rules, then the defense also respectfully requests whatever relief the court deems appropriate. Thank you, Your Honor.
Thank you, counsel. All right. I've heard arguments from both sides. I've viewed the evidence that has been provided to me. I have heard the testimony of the witness. To summarize, this is a civil case. I view it to be about a lost payment for bail and excessive force with some rights violations. The standard for ruling in a civil case is preponderance of the evidence, which is simply all I have to do is find one side's more likely to be liable than the other based on the totality of the circumstances. So when I review this evidence, I must consider the point of view of the accused officer, what they knew at the time, and what their applicable training is. As for the payments, I must consider the agency that they went to and if they are represented here. The arguments about unable to identify individual officers is not convincing and is irrelevant to me. This is about liability of the department. With all that in mind, I find the police not liable. This scene was chaotic, and regardless of the available communications, it would be nearly impossible for any reasonable officer to have a full understanding. I believe, and I think the evidence shows that the officer acted within their most reasonable ability. They did not use lethal force to attempt their arrest or detainment, even though it resulted in death. Because of that, I find no policy fault with the police as far as rights violations or excessive force. The police have also made a compelling argument that they did not receive the missing bail payments, and there's no evidence to suggest that they have, and so I am also dismissing that portion of the claim. This is my final ruling. You may make your appeals in the applicable matter, and unless there are any, at this time I will open the floor to any clarifying questions regarding my ruling. I will not entertain any additional arguments about it. Plaintiff, do you have any questions?
Well, this was not against the SWAT officer. It was against the PD officer arrested.
Counsel,
officer,
I am going to stop you there. I would like to, counsel.
That was the
Counsel, I would like to remind you, I am no longer hearing any additional arguments. I have made my ruling on this matter. This is simply for clarification on my reasoning.
This was not against the full PD. This was against the one person.
I'm saying this is
individual,
not justice, guys.
And that is the last statement I have to make. So,
Counsel, you are welcome to file that in appeal, and it will be heard by a third party. Okay, very well. Thank you. Do you have any additional questions?
No, sir.
Defense, do you have any questions?
No, not so much as a question, because it
Tell him,
doesn't
guys,
seem like
tell
he
him.
asked one. My only statement in response to his is to say that they did not issue a.
I don't want. I am
a
done
court
here. I'm
proceeding
going to
for
stop
the
you there, like I
individual
stopped
alleged.
him. I am not hearing any additional arguments regarding my ruling. There was a question about who gets paid for the lawyer side. Each party's responsible for their own lawyer's fees. That is my ruling on that. Are there any additional clarifications on my ruling about why?
Your Honor.
Okay. All right. If there are no more questions, this concludes the case of Freeman versus PD. Court is adjourned.
All rise.